Good day, I am Niljan Floreta, 22 years of age and currently residing here at Bishop's Residence, Davao City as a receptionist and landscaper. So I have been residing here for almost 3 years. And also I am serving as a reservist at Philippine Navy Marines. So before we will start with my discussion in Technical English 2, let us first define what is the subject matter all about. So CDI2 or Technical English 2 is all about legal forms. So legal forms are prototypes of any document or forms used in legal transactions or judicial proceeding which contain important matters conveyed in technical terminologies and presented in a suitable and systematic order in accordance with the circumstances of any case. So ang legal forms, there are two types of legal forms. Ang business forms and judicial forms. So under the business forms are deeds, contracts, these are used in order to execute legal transactions, that is why ang mga deeds and contracts and the like belongs to legal forms and falls under the business forms. Also, ang judicial forms such as warrants, affidavits, or any documents that are used in court proceedings or in judicial proceedings are also legal forms which fall on judicial forms. So now we will begin by defining some legal forms or some types of legal forms. So let us begin with acknowledgement. So an acknowledgement is used to verify the identity of the signer and to confirm that they signed the document. They are not swearing to the truthfulness or validity of the document. They are simply acknowledging that they signed the document. So ang acknowledgement pala is a document that only verifies the identity of the signer by stating their name in the document. So by indicating their name, it shows that they have definitely signed the document and simply making his or her identity known, that he have definitely seen and have signed the document. And this does not mean that the signer has already sweared or nagapamatuod or sinasabi na totoo ang contents ng document. So as you can see on the image or the example image, that it emphasizes the name on the spaces provided. The signer must indicate his name or her name and the date and the place where he have signed the acknowledgement. So this does not mean that the signer have sworn to the truthfulness of the document. So the next one is jurat. A jurat is used when the signer is swearing to the content of the document. The notary must administer an oath or affirmation to the signer in order to complete the jurat. A jurat also requires the signer signs in the presence of the notary. It is possible to glean this information from the jurat certificate itself. So sometimes jurat and acknowledgement create a confusion to the public because in legal forms or usually in court proceedings or in legal proceedings, both are attached to the main document, as to supplement the contents of the document. So however, both forms or both legal forms have their own definite definition. So ang jurat is a document stating that the signer is swearing to the truthfulness of the document. So parang I, Niljan, swears that my name Niljan, swears that the contents and the statements within the document are truthful. I support that the contents of the said main document are truthful. So as you can see from the example, it shows that what are the contents of a jurat. So in the beginning statement, no, it states that subscribed and sworn, so signed by me, the signer. That is the meaning of subscribe. And I, the signer, takes oath that the contents are truthful. That is the meaning of the word sworn. Moreover, no, to execute a jurat, the signer must submit himself or herself in a notary public. No, so a jurat, in order to properly execute a jurat, the person must be in a notary public, no, in order to administer, for the notary public to administer an oath or affirmation to the signer, no. So the next one is affidavit. These are types of verified formal sworn statements of fact signed by an affiant or author. Affiant means, no, the one who executes the affidavit, and witnessed by a notary public. This could be used as evidence in court proceedings. So simply, no, ang affidavits are formal sworn claims or statements executed in writing. A person that swears and executed the affidavit is called the affiant, as I have said earlier, no. So the affiant, in order to formally execute the affidavit, must also present himself to a notary public. So there are various types of affidavits, such as complaint affidavit, as you can see on the image, no, an example of a affidavit, a counter affidavit, no. There are also complaint affidavit or affidavit of loss, and many more, no. These affidavits are valid and may be used in court proceedings because it these are formal statements, no, that you present to a notary public, meaning, no, that these are truthful, or the affiant have sworn that the statements that he have said or have claimed are truthful. And also in affidavit, no, doon na ina-attach ang acknowledgements and jurats. So the next one is sales of realty. A written agreement between a buyer and seller of real estate setting forth the terms of the sales and specifying the rights and duties of the parties in the real estate transaction. It will be signed by the buyer and seller and their witness and will become legally binding upon each party. So ang name pa lang, no, so this kind or type of legal form is easily understood, no. So ang sales of realty falls under business transaction. Under sa legal form, it falls in business transaction. So this means the sale of a fixed property, or example, ang land, title o bahay and the like, no, it is a document where a person must execute when he or she will be selling his real property. Also, no, the facts and terms about the realty or the property are stated in the document. So our reference will be the example of the document. So real estate purchase agreement. So this is the example image. So as you can see, no, that it must state important details such as the identity of the seller. Here in the blank, you will state who is the seller and the buyer. Also, no, the time as well as the initial payment or deposit and so on. So the next one is sales of personal property. An agreement between the seller and buyer for the seller to sell a certain piece of property and to the buyer, and the buyer to buy the said property from the seller. The contract contains the basic terms of the sale such as purchase price, payment terms, and warranties. So like the previous document, no, it also falls under business forms, selling a personal property, not limited to real estate. Only unlike the previous document, so any valuable personal property na isell sa seller, so whoever man siya mag-create og dealings or agreement, the seller and buyer can definitely make use of this type of legal form to be used in future, no, as reference of proof of purchase or exchange of items or goods. So the next one is mortgages, a legal agreement by which a bank or other creditor lends money at interest in exchange for taking title of the debtor's property, with the condition that the conveyance of the title becomes void upon the payment of the debt. So based on my understanding, no, ang mortgages are contracts within creditors or mga gapautang such as banks or persons in exchange of your valuable property as collateral. So failure of payment will with interest, no, will cost the debtor or ang umutang, no, will cost him his property. So ang imong property na imong gigamit as collateral will be owned by the debtor, or if you will be able to pay the debt including the interests, then you will take possession of your collateral or your property back. So next is called the power of attorney. The term power of attorney refers to a legal authorization that gives a designated person the power to act for someone or for someone else. As such, a power of attorney gives the agent or attorney in the fact the authority to act on behalf of the principal. The agent may be given broad or limited authority to make decisions about the principal's property, finances, investments, or medical care. So the document or this document, no, the power of attorney is used to give authority to a person or agent besides the owner, to give authority to a particular person to act or decide on behalf of the principal or owner of the properties, finances, investment, personal care, and the like. So ang document, no, simply delegates his authority, the principal's authority, to an agent or a person. It can be, or the principal can delegate full authority or only partial, no? So pwedeng niya i-delegate na siya na dyan ang bahala, or only partial responsibilities. So it indicates, no, that the person or the agent will take charge or take responsibility towards the principal's business or investments, finances, and the like. So the next one is special contracts and agreement. A contract depending for its validity upon the formality of its execution, called also formal contract, special or special contract. So as you can see on the example, contract of indemnity. These contracts are examples of special contracts. So the next one is gratuitous contract, a contract for the benefit of only one of the parties, the other party receiving nothing as consideration. So it is easily understood na, no, that this simply means that a gratuitous contract from the word itself, no, gratuitous or gratitude, is a form of rendering gratitude, meaning there are no exchanges of goods or services made. Only one party, will benefit from the other. So the one who will render his services will provide the gratuitous will be the one that will be rendering the services and will not receive any form of services or goods or items from the other party. Only the one party will receive the benefits. One party will benefit from the other. This may be in forms of financial assistance or rendering their services for free and the like. So the next one is summons. An official notice telling a person that he or she has to appear in court at a specific time and place to answer a criminal charge. Summons are given to a person who has already been charged with an offense. So after being charged with an offense, you will receive a summon, pero pwedeng ma-receive ang summons within the mail. Then next one is appearance notice. An official notice telling a person that he or she has to appear in a court at a specific time and place to answer a criminal charge. So ang appearance notice, the person have not yet charged of a crime. So wala pa siya na-chargean og crime. So this notice will serve as a notification for the person to answer to a criminal charge. So specifically, an appearance notice is given to a person before he or she is charged with an offense. Unlike the summons, the person has already have been charged with an offense. So ang appearance notice have not yet. So hindi pa siya na bibigyan ng criminal offense. Usually a police officer gives the appearance notice. So also unlike the summon, pwede lang siya ipadala and it can only be received in the mail. However, ang appearance notice must be personally given by a police officer. And the next one is subpoena or subpoena. An order from the court that requires an individual to be somewhere in person at a certain place. Date, time to testify as a witness in a case. A subpoena is a legal document that commands a person or entity to testify as a witness at a specified time and place. Or a subpoena is like also a summon. However, it is used to testify in court proceedings. So on the image is an example of a subpoena. The next one is warrant of arrest. A written document issued by a court ordering any peace officer to bring the person before the court so that he may be bound to answer for the commission of an offense. So warrant of arrest are issued by the court and given to a arresting officer to look or to search for the person who is charged with a crime. So ang warrant of arrest is very important document, especially for law enforcement to apprehend or to legally and ethically, morally apprehend a person. So it is part of the criminal procedure that a arresting officer must present a warrant of arrest in order to arrest a person unless of some circumstances that the person is or is about or have already committed the crime So those are the only times that any peace officer, police officer, law enforcer, or a private person can arrest a person, no, without a warrant if such circumstances take place. And the last one is search warrant, an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. So, like the warrant of arrest or arrest warrant, no, ang search warrant is used to allow a peace officer, no, to search the property for evidence that may be used in court proceedings to prove the guilt of a suspect or accused. So without a search warrant, any peace officer or law enforcer cannot conduct any search to a suspect or accused or to the accused's property. So ang search warrant, no, is also a very important legal form or document in the law enforcement in order to prove the guilt of the accused, and also to provide evidences that are very essential to court proceedings in proving the guilt. So thank you for watching and listening, no. That is the end of my report. Stay safe and God bless po.